they're going to wave at it. Oh. All right. Thank you very much. Hello, everybody. Hey.
Hey.
Hello, everyone in the chat. Anyway. Welcome to Legal Self-Defense for Streamers here at TwitchCon. We're almost at the end of TwitchCon, strangely. So we saved the best for last and the most exciting possible talk for last, which is law stuff. Woo! Yes. Can I get a show of hands? Who went to the other legal talk yesterday that was new media rights? Okay, good. So we might, I know you did, but we might repeat some of that content, and that's okay, because we're trying to get through us yammering on for as long as possible. Like, we're lawyers, we can talk all day, it's great, but like we want to have you asking us questions, because I think that will be very valuable. So we're going to do a little bit of like high-level, important points, etc. But before we get started, we have to have disclaimers, because we're lawyers. The most important one is that we are not Twitch. So yeah, we don't speak for Twitch. Twitch didn't see these slides. They didn't approve anything we say. Don't hold it against Twitch if we say something crazy. This panel is not officially legal advice. If you want for reals legal advice, come find one of us. We'll go somewhere private and talk. But you know, I always say, like, if you went to court and say, you know, I'm right because some guy at a panel at TwitchCon said this was okay to do, it's not going to go well. Don't do it. So it's not legal advice. All right, we're going to talk. Let's just go to the next slide. All right, who are we? Everyone watching from home has handy dandy things they can follow along, but this is for the folks in the audience. I'm Jim. Hi, I'm Privacy and Security Counsel at GitHub, although I'm not here on GitHub's behalf, just as a Twitch user. I do stream at Twitch TV/FalconRed with a 0 instead of an O because somebody took my name and never uses the account, ever. Anyway, this is Joe. He is a partner at the law firm of Dury and Tangri, and he usually costs a lot of money, but he's here for free today, which is great. And then we have Parker. Okay, how many people here have ever bought a Humble Bundle before? All right, Parker, that's how many people have paid your salary in this room.
Thank
alone.
you.
All right. And he's the director of copyright activism at the EFF, the Electronic Frontier Foundation.
And I should be clear, I'm not an attorney, so what I say is even less legal advice.
No,
because yours is not legal advice.
No, I know, but like, yeah, you work with attorneys all day.
Yeah,
so
I work with a lot of attorneys.
All right, this is why are we up here on the stage to talk to you? We're going to provide some basic training, mostly around copyright and EULAs and user license agreements, because those are like the big top issues that are going to face you as a streamer. And then also give you some general advice on how to think about these legal issues. I mean, you're all taking the time to be here and get educated, and that's great, but not to spoil you too much, but we don't want to scare you in any way, and so we're going to give you a way to kind of handle these things. Because you can go down that, you can get scared real fast, because we're going to say illegal, don't. So it's okay, it's all right. And then we're going to answer lots of questions. So there's a microphone here for the audience. Once we get toward the end, you know, please form an orderly line. And then we're also going to try to answer questions from the chat if they're not too busy spamming Resident Sleeper once we're done talking.
Or making fun of my ThinkPad so far.
Oh. Could have been mine. Thanks, chat. Anyway. All right, so first up, we're going to toss it over to Joe for a very brief explanation on what is copyright anyway.
All right, so what is copyright anyway? I'm a copyright lawyer. I do copyright litigation all day long, mostly on the defense side, the good kind of copyright lawyer as far as I'm concerned. I want to tell you just a little bit about copyright law, and I'm going to start with the total basics, just to sort of lay the foundation for what may be your awesome questions, including hypothetical questions later on. I'm talking here, I know there are, some of you may be from outside the United States, some of the viewers on the stream may be from outside the United States. I'm going to be talking about US copyright law, and I think we're all going to be talking largely about US law here. But a lot of these principles apply more broadly, although in slightly different ways. Copyright law protects expression, not ideas, not concepts, not sort of functional things, but expression. Songs, video games, you're expressing yourself in some fixed form. And it regulates particular activities having to do with expressive works. It regulates making new copies, right, without permission. That copyright law calls it reproduction. It regulates public performance is what copyright law calls it, and we'll be talking a lot about that today, because that's otherwise known as streaming, right? Streaming of a copyrighted work is something that is regulated by copyright law. And it regulates making something new out of an existing copyrighted work. That's called a derivative work. So taking a novel and making a movie out of it, taking a video and making a different video out of it, a commentary video out of it, all those things can be taking one existing work and turning it into a new copyrighted work. Those things are regulated by copyright law. So just to give some examples of acts that might be regulated by copyright law, playing a video game and streaming it while you're playing it is a public performance that might be regulated by copyright law. Taking a piece of music and playing it in the background while you're streaming, along with your voice, may be something that it may be a public performance regulated by copyright law. And as I'm sure many of you guys know, recently, Twitch has changed its policies and come up with new policies on sort of where music can appear, where music will be muted, whether music will be muted in VODs, what music will be muted in VODs, that kind of thing. And the reason for those policies is that those kind of acts are implicated by copyright law. So what's copyrighted? I think that we can just start as a sort of first approximation with everything. Anything that's fixed in a tangible medium of expression, which is the words that the law uses, anything that's written down or recorded in any form has copyright rights associated with it. You can register a copyright, and that gives you certain additional sort of perks, but it's not a prerequisite for having a copyright. Any of you who have streamed and there's a VOD of your stream sitting there, that is a copyrighted work, probably, in which you have some copyright rights. So once anything's written down, copyright law sort of kicks in. As I said, copyright registration doesn't sort of matter a ton on this end of things. That is, before we get to court and start sort of figuring out who can sue who for how much and whether you have to pay this or pay that or pay attorney's fees or whatever. Set copyright registration to one side. Once it's written down, it's copyrighted. That's copyright basics. But that's not the whole story, right? The whole story isn't what you can't do and what copyright regulates and what copyright says you might need permission for. The whole story includes lots of other things. Some of those things are things that Parker's going to talk about that's fair use. There's another piece that I want to talk about before Parker gets to fair use, and that is the DMCA. Who here has heard of the DMCA? That's everybody, right? Now, what's the DMCA? The Digital Millennium Copyright Act. This is a law passed in 1998. And some of the things that make no sense about the DMCA will make more sense if you understand that the DMCA was passed in order to protect operators of websites. That's what it's there for. It's there to protect operators of websites from having copyright liability as a result of people posting things on the web that they shouldn't, or that somebody out there thinks they shouldn't. The whole point of the thing is determine the situations in which operators of websites can avoid liability for things that their users do with respect to copyright. And that's how you get all of and what leads to all of the pieces of the DMCA that you guys have probably had contact with, the takedown notices, putback notices, 3-strike stuff, repeat infringer policies, and so on. So let me talk briefly about the pieces of this part of the DMCA. It says that if a website meets certain requirements, the website doesn't have liability, and the copyright holder can't sue the website. One of those requirements is that when they receive a takedown notice that meets all of the requirements that are set forth in the law, they have to take down the material, at least until there's a counter notification, at least until the poster comes back and says, hey, that was a mistake, or you really shouldn't take that down because you misidentified it, or you're mistaken about the law, or something like that. They don't have to respond. The website doesn't have to respond to takedown notices that don't meet the format, don't meet the requirements. That's why you'll see on a lot of websites, including Twitch, a DMCA page that tells people how to, send a takedown notice that they will comply with, and all of the things that you could get wrong. So if the takedown notice doesn't have an identification of the copyrighted work that was supposed to be copied, or an identification of the place where you could find the allegedly wrongful copy, or a statement that the copyright holder or whoever's sending the takedown notice has a good faith belief that the copy is actually illegal, all these things are in the law, or a swearing under penalty of perjury that the person sending the takedown notice is actually a representative of the copyright holder and not just some random guy. If it doesn't contain one of those things, it's not a valid takedown notice, and ordinarily a website won't take down in response to it. And there are court cases that say, you know what, you can just ignore it if it doesn't meet the requirements of the law. So let's say one of these comes in, let's say it meets the requirements of the law and it leads something to be taken down. What happens next? Well, the person whose stuff was taken down, the user, the poster.
Your stuff.
You guys. Although, note, let me pause here the copyright holder in this situation is not just a big corporate bad guy. It may be a big corporate good guy. It may be one of you, right? If your content was taken by some other account and reposted, or your content from some other site was taken and posted someplace by somebody who didn't ask and isn't permitted to do so by the law or something. And in that circumstance, you're the one putting together a DMCA notice that meets these requirements and making sure that you've met all the requirements and sending it in. So this is, you may be somewhat more likely to be a recipient than a sender, but you can be a sender too, because anything that's written down, that's your expression, you have copyright rights in. So, counter notifications. If your stuff's been taken down and you have a basis for thinking that it shouldn't have been, what the law says is that you have a good faith belief that it was taken down as the result of mistake or misidentification. And that word mistake may mean they have you think they just, made a legal mistake. You disagree with their view, then you can send a counter notification. That has certain requirements too. One is that you have to identify the stuff that got taken down. You have to identify that you're the person who posted it. You have to swear under penalty of perjury that you think it was removed as a result of mistake or misidentification. And you have to, if you live in the US, say that, the subscriber address that you've given is a place where if somebody, say, wanted to sue you, they could do so there, and you wouldn't fight them about whether it was the right court or not, etc. That can feel scary. Counter notifications are sent relatively rarely, and I think they should probably be sent more because there's a lot of bogus takedowns. There are a lot of non-bogus takedowns, to be clear, and if the takedown of your stuff was a non-bogus takedown, you shouldn't send a counter notification because you wouldn't be able to say in good faith that there was some mistake or misidentification going on. But the process is the stuff stays down for 10 days. This is an unfortunate piece of the law, but the stuff stays down for 10 days. If there's a counter notification, the website can put it up after those 10 days, and it can stay up, and the website still isn't liable to the copyright holder. Note, this is a law about the liability of websites, not the liability of people who post things on websites, and nothing about the DMCA takedown process takes away potential liability for somebody who posts infringing stuff. However, as a practical matter, and we're going to be talking a lot about practical matters, if there's a takedown notice and the stuff comes down, the likelihood that the copyright holder is going to say, the stuff is down, but I want blood, and go sort of sue somebody is that situation happens more rarely. So that's the takedown process, that's the counter notification process. You may have noticed that I said it both in the takedown process and the counter notification process, you've got to say that you have a good faith belief that either in the takedown process that the use isn't authorized by the copyright holder or the law, or in the counter notification process that it was taken down by some kind of mistake or misidentification. And there's a piece of the DMCA, and this is actually, turns out, much more useful for people who are getting takedown notices than people who are getting counter notifications, because there are just a lot more takedown notices. If somebody sends a takedown notice and it's bogus, and I think one can say more or less they knew it was bogus, or they really, really should have known it was bogus. What the law says is that they made a knowing material misrepresentation in their takedown notice or counter notification, you can sue them. And that is happening a little more, and there's been sort of some recent developments along those lines that Parker's going to talk about. So that's the general framework on copyright law, what's protected by it, and the DMCA, and I'll throw to Parker to talk about other stuff before Jim.
Right. So I was going to say, so you talked a lot about how Twitch can protect itself by using the DMCA process, but now we also want to talk about how they can protect themselves if they get a notification, and that's Parker's job.
All right. Hey, everybody. So first, I'm actually going to start with the last thing that Joe said, talking about what you can do when in those cases where the notice was so bogus that you can sue over it, which is it is pretty rare. And one of the reasons that it's so rare that this happens is because it's really hard to win one of these cases, because you really have to show that the notice was so bogus. And it's probably harder than it ought to be, I'd say. Few people have won. Joe is one of the people who have won, although you had a leg up by the other person not showing up.
Showing up, yeah.
But that's.
But you still won.
Like,
you still won.
You did win, and not many people.
It would have felt bad.
It would, yeah. One of the other cases that's sort of high profile, it's been going on for a long time, that's a recent development that Joe was talking about, is one that the organization I work for, EFF, has been involved in, which is called Lens, or frequently the dancing baby case. And this is about a 29-second home video where a toddler is dancing around, and there's a, oh yeah, here it is.
It's like I'm prepared or something.
Yeah, that's very nice. And there's a Prince song playing in the background, tinny, because it's not it's just on in the background. And the baby's dancing, and it's 29 seconds, and the woman took a home video and put it on YouTube, because that's the easiest way to share it with your family at this, especially, I should say, 8 years ago. This is a very, very long-running case. So for 8 years, basically, there's been litigation back and forth over. This was very likely a fair use for reasons that we'll get into what a fair use is. Should Universal have to think about that at all? Does the fact that it's a fair use mean that they're sending this is bogus? And that's fortunately what we got from the court last week, right, on Monday, was that, yeah, you have to think about that. It's still like not as far as it could be, and it's not as clear as it could be too. But it's been a very long and hard-fought victory in that arena. That fair use is a use authorized by law. So now let's take a step back, and we'll go to what is fair use.
Can Keynote not go back? Oh, come on, Keynote, really?
There we are. So fair use is so Joe is describing the things that copyright covers, which is in terms of stuff out there in the world. A first order approximation is everything. That's pretty good. But it doesn't cover everything that you can do with those things. So some of the things it doesn't cover is, for example, a private performance. So if you're not streaming online, but you want to have some friends over to watch you play video games, that is not something that a copyright holder could regulate, because that's not one of the rights that they have. But there are also ways that there are authorized uses that you can make that do involve the same kinds of uses that are covered by copyright, but because when you weigh these 4 factors, and maybe some other factors too, they are deemed to be authorized by the law. So what are the factors? They're the purpose and character of the use, the use in question, so how you're using the work, the nature of the copyrighted work that you're using. So in the case of this room, it's probably a video game itself, or maybe it's video game cover artwork or something like that. The amount and substantiality of the copyrighted work used, the amount, whether you were showing the whole thing or just a very small portion, and the effect of the use on the potential market, which is it's sort of a hard one to apply, because sometimes, you can say that, for example, if you write a book review that uses that quotes from a book, and it's a scathing book review, and that means that nobody buys it, that is not any less of a fair use. It's just if you're substituting for that use. And for video games, it depends on whether you think of the use of a video game as being entertainment or as being playing video games, and whether you think of there being a market for example, licensing video game footage. So this happened with music samples. When music samples first started getting used, judges who were doing this analysis said the effect on the use of the market, well, there is no market for licensing samples. This hasn't been done before. This is just something that people are doing with records. And then other judges said, well, but if they started licensing samples, then the fact that people are using this without a license would really wipe out that market emerging. So for those reasons, it can be complicated. And usually when you're doing a fair use analysis, there's stuff that you can do yourself or with a lawyer, and you can say, like, looking at these, and you don't have to check all the boxes, but looking at these, is this probably a fair use? And you can make a decision, you can look at other cases. But a lot of times, really the ultimate say is what a judge says, is like when you're in court, does a judge think this is fair use? So in that case, it can be less immediately useful, but it's especially less immediately useful when you're talking about real-time stuff. So if you are hosting a stream, it's, so far it's the case that if you're streaming on Twitch, you don't have to be doing this analysis necessarily in real time. But on other platforms, and you can imagine on a Twitch of the future or other platforms of the future, it may be that this analysis is being done in real time not by human beings, but by algorithms saying, oh, this matches something, and they might think, does it match it enough? Is this being used to comment on the original thing? Is this being used in a transformative way? Or they might not. And if they don't do that, then they just take the stuff down. And when they take the stuff down, that's, the DMCA is designed to protect them if they leave stuff up, basically. If stuff is on there, they're not liable. But there's not a lot of recourse if they take more down than they ought to. And so that's a real problem for the future. That makes this fair use, it's not a moot point, it's still a very important point, and it's a very important right that you can exercise. But if an algorithm takes your stuff down, then it takes your stuff down. And so at EFF, we push back on that. We give them hell. We say that you should recognize fair use rights. I strongly believe that you should recognize fair use rights. But that is more of a normative thing than a legal thing.
All right. Thank you, Parker. So even if you have a fair use, there could still be other little traps awaiting for you in the EULA for the game. And so I'm going to talk very briefly, because we've talked way too long already. I see the clock. Oh my gosh, why do we talk so much? All right. The EULA, so the end user license agreement. So pretty much every piece of software that you use, every game you use, has a EULA. I'm not going to ask how many people actually read all the EULAs, because I don't think anybody does. I don't read the EULAs. I've gone back and read EULAs like to prep for this talk, but I don't do it in real time when I buy games. I just play the game and I just stream the game and whatever. So it's an agreement between you and the publisher of the game, and it's usually the publisher, it's not the developer. Because developers almost universally like streamers, and they like the publicity. It's the publishers, the big publishing houses, and usually the bigger they are, the more kind of jerks they can be sometimes. Those are the ones who enforce EULAs. And most of them do have restrictions on monetization for streaming or VODs, and it depends on when the game was made. If it was made 5 years ago and it still has its old EULA, like streaming wasn't really a thing. I mean, it was a thing, but no, not enough people did it for the lawyers to know to put that in the EULA. So it might not say anything about streaming. Or, you know, if it's a newer one, it might say, you're okay to monetize as long as it's just for ad supporting, but you can't charge for the actual video you make itself. Or some people are okay with all of it. It really depends. So for example, Devolver Games, which is an awesome indie developer, if you go to can I record and monetize games made by Devolver.com or something like that. It's really long. I have to look it up.
Okay.
That's the URL. The actual URL is like, can I record and monetize games made by Devolver.com or something to that effect. Google it. It just has a giant yes, and that's all it says, because Devolver's awesome. However, then if you go to if you try to find out your Square Enix game, if you try to find that EULA, and if you can or allowed to stream it, good luck. So if you go to, and I always pronounce their name wrong, and I think everyone does. If you go to Eidos Montreal, it says, okay, here's the rules for streaming or making VODs, only for stuff that we made, not for Final Fantasy or anything made in Japan. And they have one set of rules. Then if you go try to find the other set of rules for Final Fantasy 13 and 14 have completely different EULAs written by completely different lawyers, you can tell, because they're just so different. They're not similar in any way at all. And one says, I think 13 fully says no, you can't do anything. 14 says no commercial use, but then doesn't define what that means. So it's kind of well, I don't know, is streaming commercial use? What if I'm not partnered, so I'm not even making any money? It's not very commercial to me. So there's lots of weirdness there. I wouldn't recommend you read the EULAs, because good God, you might want, if you're paranoid about this kind of stuff, you can Control F or something for words like stream or VOD or monetize, and that's okay. Because there's lots of things in there that, as a lawyer, are necessary, but you don't want to read in your everyday life. But the long and short of it is there's no easy way to deal with EULAs. You kind of have to rely on publishers not wanting to be jerks to streamers, which honestly, for the most part, publishers have been pretty nice. The only one who kind of isn't is Nintendo. They have yeah, boo, that's right. Yeah, Nintendo's kind of jerks about stuff. So how do you deal with that? How do you deal with the reality that Nintendo's kind of jerks sometimes? So here's my Zen philosophy of how to deal with these legal stuff. Okay, law stuff can be scary. All right, can I get sued? Yep. Should I be worried? Nope. And by the way, can I note for the record, this fulfills the requirement that all TwitchCon talks have at least one dank meme present in the talk. There you go. Chat spam SMOrg. Okay. So yes, we talked about all oh my gosh, everything's covered by copyright, and you don't own any copyright in the games you're streaming. Fair use is a thing, but it's not really a thing until a judge says so, at which point, that's years after. It took 8 years for the Dancing Baby case. I mean, come on.
It's not done.
It's not done. Yeah. So that's not great. I just told you that you can't really read EULAs because they're annoying. So what should you do? Well, how do you deal with all this? Yeah. Take a risk-based approach. Think about how risky your behavior is in light of what we just told you you're not supposed to do. The law says that you could get sued for. Could. Or it could violate the law. Who knows? I don't know. Some of the issues dealing with streamers are actually very gray areas. And I think when you start asking questions, we got a good spam now. I think when you start asking questions, you'll see us be well, it depends, or we don't know, and that's okay, because streaming is new, and so the law takes a long time to catch up with these kind of questions. But take a risk-based approach. And what that means is, so let's say, if it's just your normal stream day, you decide to stream. It's a game that like it's one of your standard games you always play. And you know what? You just want to like blast some top 40 radio on your stream that day. And you know your VOD's going to get muted because that's what happens when you do that because of copyright issues. And Twitch wants to protect themselves and actually you from getting sued. But you don't care. That's fine. Like, that's great. Like, at least you thought about it. You're here, you're thinking about it. Okay, but let's say, what about like you're working hard on your stream and you just got some new graphics in from your graphics person, and like a much bigger streamer is going to be a special guest on your stream that day. Like you got DJ Wheat's going to come and appear on stream for like 10, 15 minutes to chat with you about your stream. Is that a good day to play Top 40 Radio or to play like your homebrew Mario game? No, that's a really bad day to do that because your stuff's going to get taken down. So like think about that. If this is a VOD you want to keep for whatever reason, like really, really want to keep, like then you should just then go back and listen to what we said and follow all the rules. But if you kind of don't care, then just do it. Just, you know, you're not going to get rewarded for being too cautious. However, like, that doesn't mean you should just like, you know, okay, one of my friends did this, was just like, he was coding while on Twitch. He was in that, in the creative section and coding. And his code window was about a quarter of the screen. And the other 3/4 was just the movie he was watching in the background. And I told him, I was like, you probably shouldn't do that. And he was like, whatever. So, but you know, you're not going to last long doing that kind of stuff. Don't do that. And then, you know,
I would go with just don't.
Don't do that.
Yeah,
Just don't do that. Okay.
Yeah.
And then also lawyers aren't that scary. Like I think we get a bad rep for being scary people who cost a lot of money. None of us are scary. You cost a lot of money. But none of us are actually scary. And part of that, we're going to get to questions. So if you want to ask questions, please line it on up. Chat, get your spam out now before we start asking questions so people can ask questions. Oh, we got a good line going.
Awesome.
But if you want help, we're not scary. You can go to EFF.org, which is where Parker works, and send them questions, especially if you get a DMCA notice or are getting sued. The EFF is a great resource. They are free. If they don't take your case, you'll refer it to somebody who will. Like Joe at that point, we'll take it for free. You can go to newmediarights.org, which did the other legal talk yesterday. They have a lot of nice, plain language, not for lawyers, write-ups on the law. Or you can come to my stream. I'm going to pimp my own stream. So twitch.tv/FalconRed. I do Ask a Lawyer Thursday. I play games while people ask me questions about the law, and I will answer them on stream. So if you're intimidated by like a lawyer and you think a lawyer's a guy in a suit who's really scary, I mean, I will just be me streaming games, and you can just casually ask me stuff. I'm trying to be like not intimidating at all. And so I've had lots of fun questions. I've had questions about FBI searching people's houses. I've had questions about paying taxes randomly. I know nothing about tax law, but that's fine. But feel free. I did my best to answer the questions. So come by and ask me anytime. Thursdays are I'm going to try to be guaranteed. Other days of the week, like I have a day job, so this is my hobby. But anyway, all right, we're going to get to questions. So you like ran up there, sir. So you.
Yeah. I was wondering, since music is such an issue,
Yes.
what about streaming rhythm games? There have been days I wanted to stream Rock Band and then thought better of it.
Yes, I think I have to read the EULA, to be honest.
Right.
Because this is an issue with the older the game is, the more scary it is, because publishers and devs weren't thinking about this back in the day, which is also, so like a lot of, actually some older games, like old GTA games too, they don't have a license from the musicians to play the radio tracks. So I think when they reissued GTA, they had to change some of the music tracks because they couldn't get the license again from the musicians. So, but the newer games, now they all know that this is a thing. So I would recommend getting the newest version of Guitar Hero or whatever, or Rock Band, sorry, whatever, that you enjoy, because I know there's differences between them, but like try to find the newest version, because it's more likely to let you stream than the older ones.
Okay, cool.
That's my risk base. See, it's like,
Yeah.
Or you can read the EULA.
Yeah,
No,
I'll
no.
leave that to her. She actually read Microsoft's latest EULA. So.
Why would you do that?
Oh, you're the one.
Hello, hi. So this question might be out of the scope of the panel.
That's
but,
okay.
I'm a new law student, actually. I'm a 1L. I go to USF here. My first question is going to be, would you guys be able to help me out with any legal externships?
Talk to us after.
Yeah,
We'll
yeah, you can talk to
send
us
you in the
later.
right direction.
You guys basically sound like my torts class. I'm really excited to just listen to you guys speak. So it's a general thing. Well, I'm interested in video game law. Would you guys have any suggestions in what I should be looking towards in becoming essentially a video game lawyer? Copyright, clearly the...
Right. Just in one sentence, there are a very limited number of opportunities for video game lawyers, but there are some. Network like crazy.
Hi,
Right. Exactly.
my name is Justin Ronquillo,
Yeah,
and
but
thank you.
okay, so I think, well, hang on. So there's video game lawyers. There's a lot of different video game lawyers. I think one place where there's not enough lawyers is lawyers to serve the people in this room, because I think, streamers who are signing contracts, if that's your job or that you want to be your job to be a streamer, you're gonna have to start signing business agreements, like your Twitch partner agreement. This is where I'm gonna get ejected from TwitchCon, or not invited back. But if you're signing a Twitch partner agreement and that's gonna be your livelihood, you should have a lawyer talk to you about that partner agreement. And I don't think there's a lot of lawyers doing that.
And
You guys should all talk to me in 4 years.
Yes,
Yeah.
talk to them in a few years.
I'll
but
be in every
that,
TwitchCon, just find me.
yeah.
If there's one other thing, so EFF works on video game cases in a number of areas. An interesting and kind of emerging one is around right of personality and kind of copyright adjacent stuff, where in sports games, is it allowed, can you use characters that are real life or that look like real life? There was a case with Lindsay Lohan, and so that's another, learn the DMCA and maybe also look at those cases.
Yep.
All right, thank you guys so much, and I'll be talking to you guys later. Thank you.
All right, thank you.
Hi, I was kind of curious. I want to do kind of like an MST3K thing. Do you guys know what you all? Okay. And so I've been wanting to do that with my friend and do things like the Telltale games, which I think works out fine with that. But there's a certain point where I feel like I would kind of run out of those kind of games. And I'm wondering, and maybe this is outside of your scope, how much of an issue would it be to maybe try doing that kind of riffing on the old video TV shows, like the Super Mario Brothers show, and just having a short clip and screwing around with that for a while.
Wasn't the original MST3K, weren't the movies bad because they were the ones that weren't renewed for copyright?
Right. Well, right. Let's. Yes.
We just got really. He just said something really technical. But that's
Right. So I think the question there is Mystery Science Theater 3000 style riffing, where does that sit? And I think sort of Mystery Science Theater 3000 itself gets licenses for stuff, but commenting on and criticizing a movie can be fair use. Whether it is in any particular case, sort of, again, as Parker says, it depends, but it can be. And the things that are going to make it more likely to be fair use are more criticism, more commentary, and relative to watching that stream just being a substitute for watching the movie on Netflix.
Okay. Thank you very much.
I got a hypo for you. What about if he records the audio and says, find your own Super Mario TV show
and sync it up.
Play it and sync it up?
Awesome question, right? Just to make sure the hypo's clear, right? Just the riff track being distributed, not any audio from the movie or any video from the movie, just sort of play this in synchronization with the movie, sort of Dark Side of the Moon, Wizard of Oz style, right? That is very, very highly likely to be okay, partially because there's unlikely to be any copyrighted content from the original in that stream, although there's going to be an argument that audio track is itself a derivative work. I think that's a weak argument and is overcome by a fair use argument, but that would be the argument. Awesome hypo, Parker.
Thank you.
So would something be kind of like if I had a timer up on the screen that was synced somehow to the video I was watching, and I could be like, hey everybody, go to this place and watch this video and hit play right now and sync it to the time, and then my audio would just be, that would be good?
That would probably be, that is very, very likely to be okay. There are ways you could do that and still create a problem, but that's very, very likely to be okay.
So publishers use automated tools to send takedown notices. And so with the Dancing Baby case, it now says that publishers need to consider fair use. What do you guys think that should mean in terms of how this, what do you guys think, what do you guys wish would happen because of that, and what do you guys think will happen because of that?
I think the dream would be like every DMCA notice has to have an actual human, reasonable human sitting there and being like, huh, did they use enough of this? What are they really doing with this? I wonder if I should really send a notice. Like that's like the dream, is like some intelligent person's actually thinking about it. But reality,
Yeah, I mean, so there's a section of, one of the things that's a little like eyebrow raising about the most recent Dancing Baby opinion is there's a section where it talks about, it says, so this is not binding, this is just what we're thinking right now. You may be able to do some of this with algorithms. And then it cites something that actually was in like EFF and Partners document from 2007 now. So you may be able to do this with algorithms. I suspect we will probably see people read that section very carefully and try to figure out how to do what they're doing, like make sure their algorithms match what what the judges said. Does that seem right?
Yeah, no, I think that's right. I think we're going to see people, and those rules are non-stupid, right? They may not be the right, like the exact right rules, but they are definitely non-stupid. That is, if it's a giant verbatim copy of nothing but the original, it's very unlikely to be fair use. If it takes, the entire video track from the original and replaces the audio track with something funny, it's much more likely to be fair use and shouldn't be automated.
Yeah, then a person should look at it.
Right.
Thank you.
So you mentioned taking a risk-based approach and understanding what the risks really are and whether you should actually continue with what you're doing. When you're talking about EULA, do the risks have the same level as they do with copyright?
I mean, I think for EULA, the ultimate bad thing that's probably going to happen is, and I don't think any publisher has done this yet, or I could be wrong, is theoretically they could, if you download the game on Steam, they could show up to Steam and be like, this guy broke the EULA, take back his game, is probably what they would do. Right. That would be like the bad thing, right? Whereas copyright, you could get sued for lots of money. So, so I'd rather risk the game. Breaking EULA, I'm not going to advise you as your lawyer to go I would not advise you as your lawyer to go break a bunch of EULAs just for fun, for no reason, and to that be your goal is to break the EULA, but reality is, the publisher has to be kind of a jerk, and then what is the ultimate outcome? What do they want to do? And I think the music industry has shown back with the old school Napster cases and stuff that they're perfectly happy to shake you upside down for money. The video game companies haven't really done that yet. Even Nintendo really just want the stuff taken down. They don't actually want money. And I think they also know that unless you're Summit 1G, none of us have a lot of money anyway. We're not making a bunch of money doing this, but if you've seen Summit's car, he has too much money.
Thank you.
Okay, so I've got a question about the DMCA. It's my understanding that filing a DMCA...
Would you move a little closer to the microphone? Sorry.
Oh, sorry. It's my understanding that filing a DMCA takedown notice is done under penalty of perjury. And these big companies like Sony and Universal and so on that file lots and lots of takedown notices, many of them automated. They send a lot of false takedown notices. It may or may not be the majority of them, but it's certainly a lot of them. And they don't seem to face any real penalty for it, even though the law requires that it's being done under penalty of perjury. Wouldn't it be possible for people who have their video taken down individually, it's not like a small fine or whatever, but since there's so many of them, wouldn't it be possible to set up a class action lawsuit and actually put a stop to this?
So let me answer that. Let me answer that this way. The question is, can we come up with a class action lawsuit against these people who are sending bogus takedown notices? Let me answer that two different ways. First way is, as a matter of civil procedure and class action law, the answer turns out to be probably not, because all of the facts in a class action lawsuit with respect to all of the people in the class have to be the common facts have to predominate over the individual facts, and exactly what was put up and taken down is going to be different from person to person.
Okay,
So
that makes
common facts probably wouldn't predominate. Now, the underlying question is, what can we do about this, right? What can we do about bogus takedown notices? And that's the question that Automatic, the people who operate WordPress, had. They were getting a lot of bogus takedown notices. And they hired me and my firm to go out and sue on behalf of the platform and the people whose stuff was taken down, a couple of senders of bogus takedown notices. Now, these weren't big media companies, these were really bogus takedown notices. One of them had made a copy of a website on their own site and then said, that's the original, take down the blog post,
Those frauds.
which was really gross. And the second was a group in the UK that had given an interview to a journalist and then was saying that the journalist printing their answers to the interview questions was copyright infringement because the journalist turned out to be making fun of them. Those are things we can do and that are being done, but class action lawsuits probably won't end up being the answer.
Yeah, and just one like sort of nitpicky thing. The part that they're doing under penalty of perjury, it is, and this is something that generally doesn't matter to most human beings, isn't the whole thing. It's like it's just a subset that they're saying. They swear, and that part is generally not the part that unless it's like one of these, they didn't consider whether the use is authorized by law. It's
Yeah, so when you say unwarranted, some of these takedown notices are automated. They're filing takedown for work that aren't even representative. Like especially the music stuff. They're false positives on music detection. Would that be considered an unwarranted takedown notice?
it's been tough to get accountability. I totally agree with you that it would be good if there was accountability, and even if you didn't have the facts, just looking at the numbers of takedowns they're sending, of course they're not doing a thorough review. They just couldn't possibly be. And every once in a while you have funny fact patterns where they take down everything that has a common word in it because their TV show has that word in it or something. And there was one like Fox was taking down anything that said Homeland. And like Cory Doctorow had a book out called Homeland at the time, and he's like a major copyright activist, and they were sending takedowns for his stuff. Unfortunately, it has been hard to actually get legal accountability for that, even though like those are obvious cases. Nobody looks at that and says it's right.
Yeah, but I think part of it too is like if you happen to get one of these notices, don't just be sad and be like, oh, I got a notice, oh well, I'm screwed. Like, talk to people who can advise you about it. And like, if you can fight back, you can fight back. And there's ways to do that. So don't be scared if you get, don't be scared if you get one. You may have to change your behavior, but don't be scared.
How you guys doing? I was just wondering, so I'm an unpartnered streamer and I don't have much to worry about now, but as far as my copyrighted, or my content, which, is automatically copyrighted because I created it, to what extent should I, in the future, after I'm partnered later on, to what extent should I be protecting that, or is there anything besides just the natural copyright that it comes with? Is there anything else I should be looking into, or am I pretty safe just with that? Okay.
Well, there's some other stuff. It's not necessarily copyright, though. I would say if you have like a logo for your stream, that's your trademark, and you should probably go get it registered. Probably. It's nice to get it registered. And then also kind of just being more savvy around other elements of your stream. Like if you don't make your own like emoticons, like I don't know if you make your own or if you have someone else make them for you. If you have someone else make them for you, you should probably have like an agreement with them that says, I pay you money and those are mine now. If you don't have that, it can be legally questioned. It gets annoying. And then maybe the artist later is like using them somewhere else and you're not cool with that because you're like, hey, they're supposed to be mine. I mean, that's what contracts are for, is to like work all that out. So, but, we're in a community that, we like to do things for each other, we like to help each other out, and sometimes it can feel weird to take a step back and say, well, maybe we should have a formal agreement instead of just being like cool with each other. But, it can get important. It can get frustrating in the future if you're forced to change your artwork because you didn't work that out in advance.
So the stream is safe, but the elements of the stream are what you have to look into, pretty much. Like the
I mean, yeah. I mean, we could do a whole another really long panel about all the other aspects.
I
And then
would-
chat would be really bored. But
So, yeah, I mean, we're mostly on the defensive end of this. And from that perspective, I would say, like, if you find something that you think is a copyright infringement of your work, I would recommend taking a deep breath and saying, like, is this something I want to go after? Because sometimes it's like, if it's not hurting you, if it's not, like, it may be something that makes you angry, but if it's not hurting you, it could just be, you don't want to be in the same class as the people who do this as bullies. And which, I wish that there weren't people doing it as bullies, because then it would be an easier question, but that is the reality of it.
Yeah.
Hey, I'm just curious on using subscription-based music streaming software on the stream, something like Spotify or digitally imported or SiriusXM, and how that will affect the stream, or whether it'll be taken down if it's subscription-based and you're paying for that software or for the website.
Right. So whether this music that ends up in the background of your stream is coming from in-game audio, a Spotify stream you're paying for, a CD you're playing on your computer, a janky MP3 that you downloaded from Napster in 1999, right? Like, there's a variety of possibilities. As a practical matter, what will and won't get muted in VOD, it doesn't make any difference, right? The Audible Magic software that they're using can't tell the difference between something on Spotify and janky MP3 from 1998, right? But it also, as a sort of matter of your risk, I'm not sure that the difference between all of those things matters anyway, because either there's going to be an issue about the streaming, and that seems unlikely, although is not like impossible, or there isn't, and whether it's coming from a paid Spotify, an ad-supported Spotify, whatever, as a matter of copyright law, what's coming through on the Twitch stream or the whatever else stream doesn't change in its nature because of where it's coming from, if that makes sense.
Yeah, that makes perfect. Thanks so much.
And I will note, if you use the Twitch music library, they give you a license to use that music on Twitch and in Twitch VODs, and you won't get muted. It's music.twitch.tv. I will note, though, that the license only extends to on Twitch. So if you save your VOD locally and then put it up on another site like YouTube, you're still going to get muted or taken down, or possibly. I don't know. It's possible. But I just want to note that for people who like to use the music library.
So I have a question, kind of applies more to YouTube, but it can apply to Twitch. It just hasn't happened to me yet. But on YouTube, I'm getting a lot of copyright things from Nintendo, but it doesn't really make sense what things they're taking down. So for example, I really like Pokemon, but I don't really play a lot of the newer ones on YouTube, at least. I play a lot of the Game Boy Color and Game Boy Advanced ones, which they didn't really have a lot of EULA back then. Mm-hmm. But Nintendo, it's not really making sense what they're taking down. So for example, some of my Let's Plays on a Game Boy Advanced Ruby version aren't getting taken down, but then funny satire videos that I do where I have a 20-second sound bite from original Japanese Lavender Town song gets copyrighted. Huh. So I'm not really sure, like, how does it work what they're taking down?
That is an awesome question. That question I think doesn't have a clear answer except to say this. Much of it may well be automated, and much of it may well be happening through YouTube Content ID, which is right. And the Content ID sort of matches whatever it matches, and if the music's in that library, it gets matched and it gets taken down. I don't think there's probably a human in the loop sitting there thinking about, hey, does this make any sense? Do your videos need to be taken down for
Right.
copyright reasons? But I guess as a practical matter, one thing that you could do is see if you can find a pattern and try and figure out what the pattern is and work within that pattern for things that for uses that you really do think are all right uses that are your own videos and your own commentary and gameplay and stuff.
Because if you're doing if you make a lot of Pokemon videos and put them up on YouTube, I mean, you might be the world expert on what gets taken down on YouTube for being a Pokemon video. Like seriously, if you do that a lot, you probably have more experience with that. I know you're more experienced in that than we do. But yeah, if you want us to make logical sense out of it for you, we probably can't do it. But
because like they take away a 20-second soundbite, but when I am running through multiple towns with tons of Nintendo copyrighted music playing in the background because it's from the game, they don't care and they don't copyright ID me and nothing happens. So I'm a little confused there.
Yeah, it's a bummer of an answer that like, well, it's their prerogative. The one other thing is that Content ID is something that YouTube built, and so if you don't like the way that it's being applied, and if there's an alternative, maybe look into it. And that's because so at EFF we push back against that sort of thing, and we say YouTube, you should make this work in a way that gives a wider berth to fair use, and but I think that at the end of the day they listen to the numbers, and if you can go somewhere else, if it makes sense to put this on Twitch and Twitch is better about this, then maybe that's something you should look into. I actually don't know enough about Nintendo's enforcement policies to know if that's the case.
And then I have another question which actually applies to Twitch. My last stream, I think it was actually my last stream before I came here, I did a ROM hacking stream because I've got a software called Advanced Map, and I love, I'll put rocks everywhere or whatever, and I love messing with it, and then I'll probably, play through the ROM hack or whatever. So I'm wondering, what is legal, what's not, because I know Nintendo lately has been really cracking down on speedrunners and also Pokemon ROM hackers because it's a Nintendo ROM that you took, which technically is illegal, and you're modifying it, so...
I think you're answering your own question, but yeah.
And I'm starting to agree with the chat, which has said that you should replace me on the panel.
Yeah, we have...
So, I know about the legality of doing it, but what about streaming it or putting it on video?
Well, yeah, so, I mean, streaming it just lets them know that you're doing it, right? Like if you do it in the privacy of your own home, no one's going to figure out that you're doing the ROM hacks. But once you stream it, it's like the giant target in a way, being like, look, I just ROM hacked.
Right, and there's this question about whether ROM hacks and to what extent ROM hacks are fair use, and that's an awesome, interesting, meaty legal question. I think many of them are likely to be, to the extent that you're taking a game and remixing it and commenting on the original and making it into something new for a different purpose.
Yeah, and I guess, so this is not a very good answer to your question, but at the end of the day, we see a lot of what we see where, especially, we look at Nintendo taking stuff down, we're like, what? This is such huge advertising. This is
free
right,
advertising.
but there's a lot of people and companies who just want to use it as a way of controlling what you can do with your stuff, and I am less sympathetic to that use of copyright, but that doesn't make it go away. So I don't think if you're allowed to ROM hack in the privacy of your own house, it shouldn't be a big deal if you tell other people you did it or if you put that online. But in practice, if that's what they want to enforce their copyright on, then that's how they might do it.
So we have time for one more question, and there's one more person.
Thank you very much.
Can you come back? Can you give your stream name? Can you tell us all your stream? Because there's people in the chat who want to watch your stream now and follow you.
Sure. Yeah, Mr. Cookie Walrus.
Mr. Cookie Walrus?
/Mr. Cookie Walrus.
All right, thank you.
All right.
So this this is a very practical question to follow up that. Could you guys give your tips on trademark search and clearance on the cheap, since most streamers are not going to go hire a lawyer?
Awesome question from Kathleen, who's also an awesome lawyer who does this stuff. So tips on trademark search and clearance. So trademarks, unlike copyrights, copyrights protect expressive works, trademarks protect indicators of the source of something, goods, services, streams, whatever, right? They're indicators of where the thing came from. And your stream name is your trademark, right? You're the only one in the world who has that, and if somebody's walking around with that on a t-shirt, they may think that t-shirt has something to do with you. What can you do for search and clearance of those things? So you want to, when you're picking a stream name or another trademark, check to find out whether somebody else already has that trademark, because A, you might have trouble protecting it, and B, they might think that it's a problem that you're using it. So what can you do? Obviously, one thing you can do is search Google, right? I mean, Google is in some ways the best trademark finding tool out there. You can find out if somebody else is using it. You can go to the trademark office site and type it in to see whether somebody else has registered a trademark on it. If you have a design that you're using, you can do an image search on the design to see similar images that are out there. I'm actually really interested, Kathleen, in your answer to this question and whether you have any other tips or thoughts on trademark search or clearance for streamers?
So as a practical matter, I would say don't just, you're going to have your Twitch stream name, but check, is that name taken on YouTube? Is that name taken on Twitter? Is it taken on Facebook? Because a lot of times people will have presences on other social media websites without being on all of them and without registering a trademark.
Mm-hmm.
All right, thank you everybody. I think we're at time right now. Thank you everyone for coming. Thank you everyone for tuning in. Thank you everyone watching the VOD, and have a wonderful rest of TwitchCon.